Well, why don't we get started? First of all, thank you all for joining us today at this business hour, the Secure Act, and the key provisions affecting retirement plans. I'm Dale Vlasic. I'm chair of the McDonald-Hopkins Employee Benefits Practice Group, and joining me in the panel today are two of my colleagues from that group. At my far right is John Wirtschafter. Next to John is Tony Pilsner. Tony is joining us today out of our Detroit office. We are happy to answer any questions from the audience during the program. For those of you here in Cleveland, you have a card that was part of the package that you were given. Feel free to write your questions on it and raise it. Someone from our staff will collect them and bring them up here for us to try and answer them. For those participants watching our live webcast, you're welcome to submit your questions by clicking on the questions link below your screen. If you submitted questions in advance of the program, we plan to cover those questions during our discussion today. We have a lot to cover, so let's get started. First of all, happy Mardi Gras. We don't have any floats, and we don't have any beads, and I'm pretty sure we don't have any carrot cake, or king cake, excuse me. We may have carrot cake, but I don't think we have any king cake. But we do have a lot of issues, part of the Secure Act. For those of you that have been in the retirement plan world for a while, having plan changes and tax law changes was something that happened with a great deal of frequency. It seemed like every 3 or 4 years we were constantly having to make changes and readopt our plans and amend them and figure out the new rules. It got quiet for a very long time, which was good. I don't know if we had any certainty, but we had some quiet. Well, the quiet is over. We're back. There's a bunch of changes that are going to change how people are running their plans, setting up their plans, going to require plan amendments. And we're going to talk about those. There's lots of stuff in the Secure Act, but we're focusing on the retirement plan. And one of the things that the Secure Act changes for retirement plans, Tony, are distributions, right?
Yeah, there's a number of provisions in the Secure Act dealing with distributions. However, I find it a little odd that an act that's supposed to be enhancing retirement enhancement, all but one of those provisions allow you to take money out earlier. So I'm not quite sure how that fits in with the theme, but as I said, there are a number of provisions, but only 2 of them are mandatory for retirement plans. The rest of them are optional, so the plan sponsors can decide, do they want to implement them, when they want to implement them, do they want to wait, do they want to do it now? They're going to have some choices. But as far as things that have to be done, the first thing that has to be done is shortening up the period of time when a beneficiary of a defined contribution plan has to take a full distribution of the participant's account. So you have a participant who dies, and their beneficiary is now entitled to their account. The current rules give a lot of flexibility. The beneficiary can decide to continue taking distributions over the same period of time that the participant was taking them if the participant started to take distributions. So if the participant was taking distributions over their lifetime, over their life expectancy, the beneficiary could continue that same pattern. The beneficiary could also elect to do it over their own life expectancy if they started within a specified period of time. So they could extend that period of time out. The default was if you didn't choose either one of those, you had to take everything out within 5 years. For participants dying after 2019, those old rules now only apply to a certain subset of beneficiaries. There's only certain beneficiaries that can take advantage of those rules. Those are surviving spouses, minor children who are under 18 at the time of the participant's death, a disabled beneficiary, a chronically ill beneficiary, or a beneficiary who is not more than 10 years younger than the participant. All those old rules are still in effect for them. Anybody else, which would be an adult child who's not disabled or chronically ill, a sibling who doesn't fall within that age range, now they have to take a full distribution within 10 years of the participant's date of death. They don't get the option of stretching that out over the participant's remaining statistical life expectancy or their own life expectancy. It's 10 years, a hard rule. Now, on the upside, that's longer than the 5 years they originally had before, but it has to be fully distributed within 10 years. So that, that's in the revenue provisions of the Act, so obviously the idea being that they want to accelerate when those distributions come into somebody's taxable income so they can generate the revenue from it. So plans are going to have to, as a general rule, if they're going to be as permissive as they want to be, they're going to have 2 sets of they can actually have three groups of rules. The current rules apply to anybody who died before 2019, no matter when those distributions are made. For anybody participant who dies after 2019, you have to figure out who their beneficiary is, if they're an eligible qualified beneficiary or if they're someone else. So plans are going to have to adapt to that, possibly. A lot of plans already have distribution provisions for beneficiaries that are faster than the current rules. There's a number of plans that say everything has to be out, everybody has to take it out within 5 years, everybody has to take it out by the end of the year, or we're just going to distribute it by the end of the year. Too bad for no matter what you want to do. And that's because all beneficiaries now, both spousal and non-spousal, can roll it over to an IRA. So plans decided it's easier for us to just move it out of the plan, put it into your IRA, and then you can deal with the rules on your own. If your plan already has one of those accelerated provisions, you have nothing else to do because you're already in compliance. But if you want to put in the most permissive distribution rules possible, the plan's going to have to be amended and you're going to have to start administering for those. Now, what goes along with that is the whole concept of stretch IRAs, which we're not going to talk about because that's estate planning. If you want to talk about that, talk to Mr. Mike Riley over there afterwards. He'll be more than happy to talk to you about stretch IRAs. But that's kind of beyond the scope of what we're doing because that's an estate planning mechanism. So that's one of the two mandatory requirements. The other mandatory piece is really only going to apply to a fairly small subset of defined contribution plans, 401k plans, profit-sharing plans. For plans that allow participants to invest in a lifetime income annuity contract as part of their plan assets, they allow them to invest their plan account in an annuity contract that's held in the plan. A plan that has that provision and then decides they don't want to do that anymore, you're going to have to allow that participant to do an in-kind trustee-to-trustee rollover of that annuity contract, even if they haven't separated from employment or otherwise had a distributable event. The idea being that they shouldn't be subject to the surrender charges or any of the other costs of losing that contract because the employer doesn't want to have that in the plan anymore. So you're going to have to make arrangements to allow for those trustee-to-trustee transfers. But again, that is already if you allow those in your plan and then you decide you don't want to allow them in the plan. There's not that many plans that I'm aware of that allow them right now. So it's a fairly limited subset, but if you do have that investment option, that's something you're going to have to face down the road, or if you want to put that investment option in, you have to understand that you're going to have to accommodate that trustee-to-trustee direct rollover in kind. So those are the only mandatory provisions in the distribution rules we got out of the Secure Act. There are optional provisions that you can or cannot adopt as an employer. The first one goes along with the beneficiary distributions, and that's the increase in the requirement minimum distribution age. As you've probably heard, for anyone who was not 70 and a half as of December 31st of last year, their required beginning date has been postponed to April 1st of the calendar year following the year in which they turn 72. You get another 18 months to delay that. So plans can adopt that. They can push it out to age 72 if they want to, but they're not required to. If your plan currently is at 70 and a half, you can leave it there. You can adopt the age 72 rule later on if you want to. You're not required to put that in. Some employers are holding that as, for example, a collective bargaining give. We're going to allow your participants to leave their money in a little longer. We're going to add it in later. But you don't have to put it in right now. It's not something that's required. As a matter of fact, in your plan, once a former participant reaches normal retirement age under your plan, you can force them to take everything out whenever you want to. The consent rules no longer apply. But if you have the 70 and a half rules written into your plan, you don't have to go to the 72. You can leave 70 and a half in. And you could do that at a later point in time. The second optional distribution provision you also may have heard a lot about are the qualified birth or adoption distributions. And under this is primarily an exception to the early distribution penalty on the employee. If they take a distribution of up to $5,000 from their qualified plan within 1 year of the birth of their child or the date that their adoption of a qualifying individual is finalized, they don't have to pay the 10% early distribution penalty. And plans are allowed to facilitate those by allowing those distributions from participants' accounts. our concern here with allowing for them is that there's a lot of unanswered questions as to how these are going to work. On the plan side, if you allow these distributions, there's a couple things you'll have to do. You'll have to coordinate it across all other plans in your controlled group. So if you happen to be in a bunch of related employers and there's more than one 401k plan, and somebody might have accounts in more than one of those plans because they've moved around, they can't take more than $5,000 in total from all those plans. So you have to be able to coordinate that. That's the first thing. The second thing is you have to allow them to repay it. And whatever they repay has to be treated as a rollover contribution to the plan. And they somehow, we're not sure how yet, get to treat the original distribution as a rollover distribution. So we're not sure how that's going to work. There's no time limit currently established as to how long they have to repay this distribution. So you'd have to keep that open as long as they were able to, as long as they can make a rollover contribution into your plan, you have to allow them to repay this. So if somebody took a distribution this year and 4 years down the road wants to repay it and they're still your employee, as we know it now, then you'd have to allow them to do it. You'd have to somehow be able to account for that. So there's a lot of things we don't know about this. We're hoping for more guidance. We were discussing before this, our only caution with employers adopting this right away and starting to allow these distributions is that it's entirely possible, unless there is relief given in the final regulations, that once you allow this, it becomes a protected benefit. And you wouldn't be able to take it away for any amounts in somebody's account as of the date you amended to take it out. So if you decided to allow it this year, and the rules come out and the administration's just terrible, you could take it out going forward, but any amounts that were in their account already would still have to be eligible for these distributions. It would be a protected benefit. We're not sure if they're going to give relief from that. So we're kind of waiting to see how this is going to work and what administrative obstacles or burdens we're going to have with this. It is available for any distributions made after December 31st, so the child doesn't have to be born or adopted in 2020. They could have been born or adopted anytime up to a year before the distribution's taken. But there's really not enough detail on the administration at this point for us to really be able to say how much of a burden or a benefit this is going to be for participants. So that option you might want to think about a little bit longer. Another optional piece, currently defined benefit plans are allowed to let individuals start taking their benefits at age 62 even if they haven't terminated from employment. It's a permissive option. A plan can allow somebody to start receiving their benefits while they're still working. Employers who do this to encourage phased retirement, to facilitate some kind of succession planning. That age is going to be lowered. It has been lowered at 59 and a half. So now the in-service distribution age in defined contribution plans and defined benefit plans is the same. At age 59 and a half, you can start taking your benefits out of your plan. I'm sure John and Dale can tell you that the complications of allowing an active participant to start taking their benefits and the recalculations that would have to go along with that are probably fairly complicated. But it is out there, and that rule has dropped down to age 59 and a half, beginning with plan years that start after December 31st of 2019. And then the final optional item is really additional information, sort of like what we want on the qualified adoption and birth distributions. We finally got additional information on the qualified disaster distributions and loans that you've been able to make since 2018. They finally got around to giving us some more guidance on that, and they've also sunset it. So it actually only applied to qualified disasters declared beginning 1/1 of 18 through 60 days after the enactment of the Act, which passed last week. So technically, there are no more qualified disasters for which you can make a qualified disaster distribution or loan. You can make the distribution of the loan for another 4 or 5 months. You can make it till sometime in June. It's 180 days after this was enacted. You can still make those distributions, but they are sunsetting. And so we have some more clarity that the distributions can be a total of $100,000 per disaster from somebody's qualified plan. They have 3 years to repay it. And again, it's the same kind of thing. If they repay it, the original distribution is treated as a rollover that was successfully made. and the money that comes in goes back into the plan as a rollover distribution. For loans, qualified disaster loans, the limits are increased. They're $100,000 or 100% of the account, whichever is lower. And payments can be suspended for up to a year after the disaster without it going into default. But again, that's kind of sunset. If you didn't put those in originally, you're probably not going to do it for distributions that can be made over the next 4 months. But it's interesting that they finally gave us some guidance on something that's been out there since 2018. Hopefully we won't take that long to get the same kind of guidance on the adoption and birth distributions. But those are the only distribution provisions. And again, most of them are accelerating distributions, which just seems kind of counterintuitive.
It does, and you mentioned where you started with on the beneficiaries and the new rules. I think probably it's incumbent to remind people, make sure your own beneficiary designations are accurate and your employees' beneficiary designations, bug them on that. You wouldn't believe the problems that get generated because of that, and definitely with these new rules and who gets the acceleration and who doesn't get the acceleration, I think that makes it even more important. But if you ever had to deal with having no beneficiary designation, just do it. Check your own.
Yeah, and Dale, I would use this as an opportunity to plug our estate planning group, or use your own estate planning group, but these two rules are going to impact some of your estate planning decisions. And so it's another reason to sit down and talk with your planner.
Well, Tony's told us how to get money out of a plan. John, have they done anything to encourage us to get money into a plan or to make life easier for those of our clients and referral sources who have plans?
It's kind of funny. The act is called the Setting Every Community Up for Retirement Enhancement Act of 2019. And I think just coincidentally that the acronym comes out to SECURE.
Yeah. Go figure.
I'm sure they were completely surprised by that. We'll take a straw poll when we're done today of how many you feel more secure now that you understand all the provisions. I honestly do not. There are a number of changes that affect your 401k or your profit sharing or your other plans, and I'm going to talk about a few of those. And some of them are, the Congress give, and some it is Congress takes, and I don't really know in the end who's going to win on this one. So the first one relates to covering part-time employees in your 401k plan. Previously, you only had to cover people once they have a year of service, 1,000 hours. And a lot of companies have chosen to exclude their part-time employees because, to be honest about it, it's administrative hassle. A lot of these people don't end up ever vesting in any employer contributions, so you're just going to forfeit it. And even if they're not eligible for employer contribution, you have to find them. You have to put them in the plan when they're eligible. All sorts of reasons. So a lot of our plans, a lot of our companies have decided, for one reason or another, we're only going to make the plans eligible for people who have a year of service. Well, the rules have now changed, and they begin starting next year, not 2020, but 2021. We're going to have to count the hours of our part-time employees. And if they get 3 years of at least 500 hours, we have to give them the ability to make elective deferrals into the plan. Now, we don't have to make employer contributions to them. In other words, we can still have a year of service requirement for the ability to receive a match or for the ability to receive a profit sharing contribution. We can exclude them for discrimination testing because we could always exclude people who didn't have a year of service and test them separately. And of course, virtually all these people will be non-highly compensated, so it's probably a pretty safe assumption that you would pass. And we can exclude them for the top-heavy contributions. They're not eligible, but we'll have to include them. So basically, beginning in 2021, you got to count. So the first year that you would have to actually allow them would be 2024. I think that most employers are going to decide that it's not worth the trouble of trying to keep track of that. Because if you miss somebody and you don't allow them to participate, and it turns out that they met that 3-year requirement, you're going to have to retroactively go back and make contributions for them. You're going to have to correct it. So I think what most employers should and will do is just get rid of that provision that says that you need 1,000 hours to a year of service to be eligible to make deferral elections. And they'll just start making it available to any employee, or at least they'll make it available once you have 1 year of at least 500 hours, so that they don't lose track of these people. I think that's the way to go, but we'll see.
Have we thought about what the software requirements are going to be for tracking those, John? I mean,
No, we haven't. The answer is we track the hours, right? Because we need to know, for a number of reasons, whether someone has over 1,000 hours, whether they have over 500 hours for breaks in service or whatever. So we probably have that information, but it's just one more thing we're going to have to, pay attention to. And to be honest about it, I think it's just easier to just put them in the plan. You may feel differently. So the next one relates to a change that they made to what we call a QACA. A QACA is a Qualified Automatic Contribution Arrangement, and it's a plan that basically says that we automatically enroll people into the plan and escalate their contributions each year up to a certain level. And the rules are, they're kind of complex, and you have to meet them all in order to do it. But the basic rule is their first year has to be at least 3%, their second year has to be at least 4%, and you can go all the way up to 10%. And they expanded that rule to now say, well, if you want to, you can go up to 15%, and that is effective as of 2020. I wouldn't suggest necessarily changing in the middle of the year for this one. If you're going to do it, if you want to do it, it's elective. I would probably do it beginning next year, but you can go up to 15%. You don't have to, you can. This is thought to just give people, people are generally lazy. And we see that all the time with participants. They have every intention of signing up for the plan. They have every intention of increasing their participation level, but they just don't get around to it. So these qualified, these QACA accounts really take the laziness out of their way, and it puts them into the plan. It still gives them the right to opt out, or to change their elections to something else, but at least it starts that process and it escalates it each year. So QACAs are a good thing, and now we've made them a little bit even more enhanced by going up to 15%, but I don't think it's going to be a widely used provision, because 10% is a lot of money. So we'll see. And again, that is already in place now. The other thing is that we've expanded the rules for other safe harbor plans. Now, safe harbor plans are plans whereby we give a notice to the employees before the beginning of the year and make a matching contribution for them, which is immediately vested, and then we don't have to apply the ADP testing. Or we can do what's a profit sharing contribution for everyone, a 3% profit sharing contribution, and then you can make that change anytime up to no less than 30 days before the end of the year. They've expanded those rules to say that now we don't have to give a notice each year if we want to do the profit sharing contribution. We can just go ahead, put that in our plan, and do it each year. And we can actually decide to do that retroactively to the prior year if we increase that profit sharing contribution from 3% to 4%. So where I see this coming in handy is if you're getting towards the end of the year and you run your ADP-ACP test, which is the test that compares the level of contribution of your non-highly comps to the level that's being made by your highly comps. And we've all, anyone that's involved in employee benefits knows how much fun that is to go into your CEO and tell them that we're making a distribution back to you of some of your elective deferrals. So you get to that point, you have another basically arrow in your quiver. This is another option. We can, after the end of the year, instead of doing refunds, or instead of making QNECs, which are qualified non-elective contributions, in order to be able to pass the test, we can just retroactively create ourselves a profit-sharing safe harbor plan by making the 4% contribution. So I think this is just another feature or another ability for employees to not have to go back into their CEO's office and make that really, really unfavorable discussion. It used to be many years ago, and I'm sure Dale, you remember that, and Tony as well, where when you didn't pass the ADP ACP test, you went to the highest highly compensated employees by percentage. So by definition, you were basically going to the lowest, highest, highly compensated employees in your company. And people didn't mind doing that. But now you go to the highest number contribution. So you're immediately going to your top executives. And so having another opportunity or another way to solve that problem, I think is a good thing. Well, they gave us that. Now they take it away. The Secure Act increased the penalties for missing a Form 5500. The Form 5500 is the annual report that each qualified plan is required, and by that, all welfare plans that have over 100 participants or that are self-insured, and certain other plans all have to file 5500s. Even a top hat plan, unless you have filed the election or the notice with the Department of Labor, has to file 5500s. Well, the IRS has increased the penalty. It used to be $25 a day, up to I think $25,000, up to $15,000. They increased it by tenfold. So now it's $250 a day, up to $150,000. So if you weren't motivated before to get your Form 5500s in, I hope that this does it as well. Now, ERISA always had the Department of Labor with the ability to issue these as well, but we usually heard from the IRS with these lower penalties, not the Department of Labor. So this just is pushing it up to a level that's closer to the Department of Labor fine. So you don't want to do that. There's also a form that you have to file each year with your 5500. It's a Form 8955 SSA. And it just basically lists people who received or were entitled to distributions for that year. And if you didn't include somebody or you didn't file that form, it was $1 per participant per day, up to $1,000. So, I'm not saying $1,000 isn't a lot of money, but you could get away with that. And I actually had some employers that said it was cheaper for them to just pay the $1,000 than to go through the hassle. Well, that penalty has been pushed up 10 times as well. So now it's $10 a day per participant, up to $100,000. So, or actually $50,000. So that's still a lot of money. And so therefore, you're going to want to get that form in, and you're going to want to make sure that you're ahead of the game on any kind of either the Form 5500 or these, the schedule that you have to do of terminated participants. Speaking of that, and I know that Tony talked a little bit about this, but now defined contribution plans are going to have to provide an additional piece of information to the participants in their plans. And it is basically providing an annual lifetime income disclosure statement each year showing what annuity would be able to be purchased with their account balance. And you have to, once you have to provide that on an annual basis. Now, the good news for that is the IRS has to give us a lot more information about what that means before we are actually required to do that. The first year that we'll have to do that is 1 year after the latest of either the IRS issuing the final rules or interim final rules, the IRS creating a model disclosure schedule that we can use, and the IRS providing the assumptions that we can use for providing that. So we're going to have some time, and we're going to get some instructions on how to do that. But on an annual basis, in your statement, you're going to have to provide another layer that shows, hey, if you bought an annuity based on where you're at now, this is the lifetime, monthly payment that you would be entitled to using the following assumptions. And as long as you use those assumptions and follow the model that the IRS provides, there's no risk that to the company if in fact they can't purchase an annuity at that rate. But it's just one more pain that we have to live by. And this really sort of ties into a little bit of what Tony was talking about, which is that the IRS continues to want to make annuities available for participants in a defined contribution plan. And if you have a defined benefit plan, you're used to providing annuities, and any of you who have ever dealt with that know it's a real pain. It's real difficult, and it's a real fiduciary responsibility to go out and purchase an annuity. You have to go through all sorts of steps of due diligence about the insurance company that you're using. You have to, generally should hire a group that really knows what they're doing to go out and place that. You have to do all sorts of examination. And so as a result of all those requirements, most administrators of defined contribution plans have elected to stay far away from annuities. They just don't want to have that same kind of fiduciary administrative burden and responsibility. Well, the IRS recognizes that, but they also want us to go ahead and, I should say maybe Congress recognizes that, but they want us to go ahead and make it a little bit easier for participants to take annuities. So they've created some rules that basically reduce, or in some cases eliminate, that fiduciary responsibility if you meet a certain safe harbor group of rules. One of them is you have to pick an insurance company that's licensed in the state that you're dealing with. The insurance company has to file audited financial statements, which I think these are both pretty easy, and they have to maintain a reserve that meets the state requirement for each of the states that you're going to be issuing these for. So I guess the good news, and if you do that and you pick an annuity and you buy it, and that annuity company goes out of business in 12 years, you will have a safe harbor from being hit with a breach of fiduciary responsibility for that purchase. So believe me, that is not the rule for a defined benefit plan. It is considerably relaxed. And they've also, as I think you were mentioning, Tony, increased the portability rules with respect to annuities in the defined contribution plan so that you can move that annuity from your company to the next company without having a required distribution or taxes or withdrawal or anything like that. Another thing that the Act has done is that it has increased the opportunity for small employers, and by a small employer, we use the same rules that we would use to determine whether or not you're eligible for an IRA simple plan. And that means less than 100 participants in the plan, or 100, I should say, employees in the company, and that's on an expanded control group basis. But if you're a small employer, then they've increased the opportunity to get tax credits for establishing a new plan. It used to be $500 a year for up to 3 years, and now it's $5,000 a year for up to 3 years. So this can basically pay for the cost of implementing the new plan by getting a credit. This is a credit. This is not a deduction. This is real money. This is fair. And they have also increased the ability to get that same deduction if you are a small employer and you add an automatic enrollment feature to your plan, or you amend your plan to do that. So that's $500 a year. So they are trying to motivate small employers, because that's generally, most of the large employers already provide retirement plans to their employees. But a lot of the smaller employers, for whatever reason, and usually it's cost saving, and often it's not having the administration to be able to manage these plans, and nervous about that. A lot of them have not gone and done that. And participants that are in those smaller companies really don't have the same opportunities to save for their retirement, because if you have to do it on your own or through an IRA, you're severely limited. So this is just an opportunity to try and push these smaller employers to go ahead and bite the bullet and adopt these plans, and particularly to adopt automatic enrollment plans, so as to help their employees, defer more dollars. There are other, things that we should talk about, I suppose. One of them is, and this is a rule that I'm sure is going to affect every one of you, which is, for those of you who allowed employees to take loans out of the plan using a credit card or a debit card, I'd like to talk to you afterwards, because that's a dumb idea. But you can't do that anymore, so stop doing that. I've never heard of anyone doing that. I mean, plan loans it's a fiduciary responsibility to make sure that they meet the requirements, and to give someone a credit card is or allow them to do that on a debit or credit card. I recognize they have to go through the things. It's just irresponsible, and I guess the IRS must feel the same way, because Congress passed the rule saying you can't do that. You covered the one other thing, so I will turn back over to you, Dale, because I think
Sure.
that pretty much. So do you guys all feel
We do have
more
one
secure?
question that kind of goes along
Oh.
with this. If a plan sponsor adds an in-plan annuity, meeting the safe harbor requirements, do the other fiduciary responsibilities still apply? For example, do they have to monitor performance and fees?
No, because once you buy, well, you certainly have to exercise fiduciary responsibility with any of your assets. So I think the annuity purchase had its own set of additional responsibilities and requirements, and this safe harbor is intended to protect you from that. And once you purchase the annuity, other than putting more money into it, your fiduciary decision's been made. So we're going to have to wait to see how the IRS comes out with this, and more importantly, how the Department of Labor comes out with regulations that talk about this. But I would say that once you've made that purchase, for the most part, your fiduciary responsibilities are done.
Okay, good.
Tony, you disagree?
Good.
No.
Oh, good. That always scares me to ask that.
You say it with such certainty,
Okay.
John.
Well, that's part of my job.
Well, kind of following what John had talked about, part of the purpose of the Secure Act was to encourage employers to have plans. The focus has really been on smaller employers who, as John mentioned, have a certain reluctance. They don't want to get into it. It's a pain in the behind. I don't want to deal with 5500s. I don't want to deal with all this stuff that goes along with it. And so one of the themes, notwithstanding Tony's incisive, pointing out that there's more getting money out than getting in, there is a theme about getting plans in place and getting money into them with the automatic enrollment and everything else. One of the things that they have done is lengthen the time to the point in time when you can adopt a plan. For the accountants in the room or the financial advisors in the room, you all know what it's like. You're sitting down at the end of the year, it's December, you're looking at somebody's books, you're seeing how much money they make, and they don't have a plan. And one of the things you say is, you really need to put a plan in place and get a tax deduction. And so there has been, historically, a scramble at the end of the year to get a plan in place, get a document put in place, all of those kinds of things. There has been, some fear that people will time travel, if you will, after the end of the year to get it adopted timely. One of the things, no, never happened, but I've heard it talked about. One of the things in the old days, the IRS was really insistent that the trust be in existence before the end of the year. So one of our standard thoughts was to tell people, look, throw $100 in an account so that you've got hard evidence that there was a plan in place. The IRS backed off on that, say within the last 10, 15 years or so, but that was an old practice. A lot of us, I was going to say old timers, but a lot of us veterans, would encourage people to do. Well, the Secure Act gives you more time so that you don't have to scramble when you're sitting down at the end of the year, or you don't get the books closed until January, whenever. Now you can have that an employer has until tax filing due date with extensions to adopt a plan to make it retroactive.
That's a great provision, by the way.
It's going to make it a little easier. You've got time. You're not crunched up against that December 31st deadline, and your books may not be closed, and you don't have an idea. So you have more time. Tax filing deadline with extensions. The only negative I can see with that is because when you adopted the plan in December, you had time until tax filing due date with extensions to fund it. So now if you're adopting it with tax filing due date with extensions, you got to fund it. There's no extension on that. So you've got to be ready to put the money in. But I think it's going to be a good idea, a good practice. One of the things to be careful about is it's going to be effective really here in 2020. So you can adopt a plan for 20. You can't go back to 19, but you could adopt a plan for 20 sometime in 21. What you got to be careful with is you can't really retroactively adopt the 401k piece of the plan. So that if you want to have a 401k plan, you can have it, but the 401k plan can only be effective the 401k part of, because there's no such thing as a true 401k plan. It's a feature on a profit sharing plan or a stock bonus plan. That's got to be effective prospectively. So you got to be a little careful with that. But the employer side, you can make that retroactive effective. So that's a good thing. I think that's going to be positive. So the negative was you got to have the check ready to deposit at the time you make the decision, pretty close to it. So that's a good thing. The other thing that's trying to encourage especially small employers, but technically is available to all size employers, is what are called multiple employer plans. Multiple employer. You got to be really careful. It's not a multi-employer plan. A multi-employer plan always has a union involved, and they've got all kinds of issues, and you want to talk about those issues. John's an expert on that and the withdrawal liability it creates, but these are multiple employer plans. And these are plans where you've got unrelated employers coming together. And they're sharing a document, they're sharing a trust, they're sharing investment, they're sharing administration. The idea is by putting this together, you can create a bigger pot of money rather than, a plan that only has $200,000 in it. If you have 50 plans with $200,000, you've got something more substantial and you can deal with it. Several years ago, it must be longer, it must be 10, 12 years ago, the financial community started creating MEPs. And the Department of Labor said, no, we don't like this idea. We don't like unrelated employers coming together and sharing all this stuff. And these were what were so-called open MEPs, and the Department of Labor just stomped on them with both feet. And the IRS said, wait a minute, because the IRS had told what are called the professional employer organizations, PEOs. I don't know if people are familiar with those, but PEOs are where you've got an entity that brings employers together that are unrelated, does their payroll, does their HR, do all of that kind of thing, their health plans, and selling them a 401k plan for all these employers was a good thing, and the IRS had just not too recently before that told the PEOs that the only way they could sponsor those plans were to have multiple employer plans. And so the Department of Labor had to back off, and that was called a so-called closed MEP, because there was a nexus, there was a connection between these employers. It was the PEO relationship. You had some Chamber of Commerce doing these kind of closed MEPs. There was a nexus between these employers. Well, now the Department of Labor has to do a complete 180 and learn how to figure out how to deal with these open MEPs, where now you can have these open MEPs. And it doesn't have to be a small employer, but for the most part, I anticipate it's going to be small employers that are going to take advantage of that. You can join one of these, and there's going to be one document, one investment menu of funds. There's going to be all this stuff that is going to make life easier so that, yeah, it's going to cost you something to do it, but you're sharing it among 25, 30, 100, 1,000, however many employers wind up in this MEP together. So it's going to be there. We've got a lot of experience in the PEO world because we've been working in that space for a lot of time and setting these up. So we know kind of the tricks, and they got some hair on them that you got to deal with and you got to worry about. But we're going to see that, and I think we're going to see, you're going to need somebody to sponsor this thing. And it's not going to be an individual employer. It's going to be probably some type of a financial institution or a third-party administrator who's already got half or a third of the infrastructure in place to handle this. So we're going to see that. And they're going to be called what's called a pooled plan provider. You got to have acronyms. PPO, Not,
Don't we use that one already?
I don't. It's probably used already. I mean, yeah.
That's a PPP.
That's PPP. Okay.
Mm-hmm.
Okay. PPP. You're right. I should pay attention in third grade. PPP. So they're going to have to serve as the fiduciary. They're going to make all the fiduciary decisions. They're going to be the plan administrator. They're going to be the named fiduciary. So a lot of that is going to get shifted. So the people that are going to get into that, people are going to sponsor it, you're going to want them to know. And the employer getting into it, really its only fiduciary decision is joining one with a good PPP that you feel comfortable with. So I think we're going to see that. That's not effective for till 2021, I believe, is the first year we're going to see those. But I expect to see those, and I expect to see. I'm expecting financial administration and third-party administration firms going to be setting those up. One of the other things that they did to make this more palatable, there was this weird rule that was always out there and scared people. I never saw it happen in practice. It was the one bad apple. The idea that the Department of Labor and the IRS had said, well, if you have these multiple employer plans and one employer has screwed something up in their own plan for whatever reason, didn't cover people or failed a test or did something, that one bad apple ruined the whole thing. So if you ran your plan completely, no problems with your plan, which, is always difficult to say in any case, but somebody else screwed it up, you could be at risk. I never saw it happen in practice, but it was always a fear. The Secure Act eliminates the one bad apple rule, once again, to encourage people and not to be afraid of taking advantage of it. So I think we're going to see that, and that ties into the other things.
That's a huge improvement, because even though you hadn't seen the Department of Labor or the IRS pull that one bad apple, we certainly were always fearful of it, and it was an impediment towards moving towards one of these types of programs. Now you're going to have the availability of a big plan kind of economics for a small employer. So I think this is going to catch on when we understand how to do it. Absolutely.
Yeah. And kind of going along with that, John had mentioned the penalties for filing 5500s. They're trying to encourage, make it easier to comply, and this ties into the MEP idea as well, is that some related or unrelated employers, if they share certain common features of their plans, can combine themselves and file one 5500. I'm not totally sure how that's going to work yet. I can see it working in the MEP arrangement because you've got everything all together already. I don't know how unrelated employers who aren't in a MEP are going to do this, but conceptually I guess they could. Obviously, if you've got related employers, that's going to make it easier for them. But the idea being that if you've got you share the same trust, you share the same investments, you share the same fiduciaries, you share the same plan year, you can file one 5500 for all these plans, related or unrelated. What you don't get to do is if you've got over 100 participants, you'd have to have an audit. You don't get to combine them for audits, so you might have to have, depending on how many employers are together, you might wind up with some having audits and some not having audits. There's going to be a little work trying to figure out how this is all going to work. But the idea is to encourage and make it easier for compliance and make it easier and take some of the burden off of smaller employers sponsoring plans.
Dale, I presume that if the MEP itself has over 100 participants, then the audit requirement's going to be at the MEP level, and that if any of the individual employers have more than 100 themselves, they'll have their own individual audit? Sort of like what we do with the master trust kind of thing?
Yeah, I think it's going to be that way.
That's how I understand
right
it.
now, I think they're filing, look to our accounting folks who do them, I think they're filing them at the MEP level for the most part, so we'll see.
Yeah.
Another rule which is interesting is trying to encourage employers to keep defined benefit plans. Defined benefit plans, depending upon where you are, some plans like cash balance plans, which we do a lot of, those are still growing and still out there, but you've got a lot of plans in the union environment or the old-fashioned blue-collar factory-type plans that employers can't get rid of because they're not funded enough. And so employers over the years have been freezing them, and there's this concept of a hard freeze and a soft freeze. And one of the issues that happens is if you say you have a soft freeze, so we close the plan, nobody new is getting in, but everybody who's in it as of that day is continuing to move along the vesting schedule, maybe continuing to accrue benefits and still paying people out. One of the things that happens, it could happen, is as that continues in existence for that period of time and people start falling off, you may fail discrimination tests. You may not be covering enough people. You maybe have lost all the rank and file people who were in that defined benefit plan, and you're only left with the highly compensated, and if you looked at that by itself, that plan is now discriminatory. And so they have given us guidance, or they're going to be giving us guidance on how we can keep those plans and not have to do discrimination testing on those plans, on those closed defined benefit plans. So to encourage, to the extent that you freeze them, Don't make a hard freeze. You can do a soft freeze and continue to accrue benefits, so it's going to help them. Now, this is available for plans that were frozen before April 2017, and for any other plan was in existence for at least 5 years, and you didn't make any big changes in it. I think the whole point of that is to prevent people from playing games, that if I got a small employer, I set up a plan, create a big benefit, a year later, freeze it, and then now I've got it left as the owner. People wouldn't do that, would they? But I think this is designed to prevent that kind of game playing that could exist out there. So I think that is a positive. It just kind of helped that to work out. One of the other positives I think that comes out of this act is terminating 403B plans. Now, I don't know how many people we've got, how many 501c3 organizations we got here, but I know we got a number of advisors to 501c3 organizations. And one of the challenges for a 501c3 organization is if I want to get rid of my 403B plan. A 403B plan, for those who aren't familiar, works pretty much like a 401k. It gets exception from a bunch of rules. A 403B by law can only invest in two things: annuity contracts or mutual funds and custodial accounts. That's it. No stocks, bonds, none of that stuff. That's it. The problem has always been is there's this fiction where the account is not only the employer's account, but it's also kind of controlled by the individual employee. So if you wanted to terminate a 403B and you couldn't convince the person to get out of their mutual funds, you were stuck with that. You could say, look, I'm going to terminate the plan and we're not going to put any more money in it. Or you'll see it a lot of times in a hospital situation where they've acquired other hospitals and say, okay, fine, you're coming into our 403B plan and we're using these mutual funds. We're not going to put any more money into the old mutual funds. You were stuck with those. And if you couldn't get the mutual fund company or the custodian to allow you to kind of roll your plan around that plan and wrap it into yours, you got two plans that you're stuck with forever. Other than kind of harassing people and get them to move their money, you're stuck with it, which didn't make a whole lot of sense. You don't have that in the 401k world. 401k world, the employer says, yep, the plan's gone, we're cashing you out. You know, here you go, put your money in an IRA or put your money over here, but that's it. That wasn't the case with 403Bs. They're going to give us guidance, and I know I've got a couple of clients that are going to welcome that guidance when we figure out how to get rid of these things that are hanging around for a long time and wrap them up in it. And what's going to probably happen, they're going to give us guidance to say, look, I know you like this mutual fund, we're getting rid of it. If you don't move it, we're going to turn that custodial account out of a 403B account into an IRA, and it's yours. It's not mine anymore, it's yours. We got to wait for the regulations and the guidance on how to do that, but I think that's going to be a welcome situation.
Yeah, they've been in need to clean this up for a long, long time. It used to be that, you know, a nonprofit would offer a 403B and people would go out and pick their custodian. So, you know, one person might put it in one account at one bank, one might put it at one insurance company, whatever. And the employer really didn't care because they had basically no responsibility other than to put the money, send the money to where they were supposed to. They changed the rules a number of years ago, and all of a sudden these are ERISA plans subject to all the ERISA requirements. And these nonprofit employers had no idea where all these funds were, no idea how to deal with them. So they've been kind of slowly figuring out how to get rid of this for a while, and I think this is going to be a great addition for nonprofits.
Yep, I think it's going to work well. One of the things, as you can kind of, one of the subtext that's going through here is there's lots of changes, some of which are optional, some of which are mandatory. And kind of circle back to where we started this whole conversation, we haven't had to have massive amendments of plans for a while. Well, we're going to, depending upon what you're going to do, because most plans don't permit some of the things we're talking about. They don't have the covering people who are part-time. They, you know, most plans right now say, you know, required minimum distribution is 70.5. How are these things going to work out? So there's going to be plan amendments. And kind of what's going on in the plan world, if you're not in this world totally, is the IRS has been pushing people out of kind of individually designed plans. They're not giving determination letters anymore, and they've been moving into what they now call pre-approved documents, whether they are the adoption agreement type, where you've got a limited amount of choices, or they're more sophisticated, where we would call them volume submitter documents, which you don't call them that anymore. They're called all pre-approved. Pushing you into that. There's going to be changes, and you're going to have to make those changes at a period of time. You can make a decision on how you want to operate your plan, and you can operate it in accordance with however you decide to operate it, whether you're following or not following the rules that you have choices about. You got to operate it, and then we're going to make amendments probably by the end of the 2022 plan year, or later if the IRS pushes it out. But I think you're going to find, and Tony, you can comment on it, because I think you've been battling a particular provider, is that because we're moving into this pre-approved world, some of these choices may not be yours, are they, Tony?
No, the age 70 and a half versus age 72, my impression from some early conversations is that the large third-party administrator pre-approved plan providers are going to make that a mandatory change across their platform, because that is how they are programming their platform. So to the extent you're in one of those plans, you may not have that choice. They may say, look, we maintain the pre-approved document, we are making this change, and that's how we're going to administer it. So, you may not have the choice. If you're in an individually designed plan but being administered by a third-party administrator, the question is, will their platform support you leaving it at 70 and a half? Or are they making a universal change across their platform and they're not going to be able to accommodate that for you? In fact, I asked Dale what we're going to be doing with our pre-approved document as far as the 70 and a half versus 72.
It's going to be 72. No,
There's something to be said for the consistency and the programming, and like I said, I've already been battling with at least one large TPA about this. They immediately came out and told me that it was required by law. I said, no, it's not. And the employer I'm dealing with has an individually designed plan, but they've come back and said, no, we realize it's not required, but we're doing that. We're implementing that across our pre-approved platform. And we're not sure at this point if we could administer this individually designed plan with if they keep the 70 and a half. So they're looking into that. But so where you may not be legally required to do it, you may have some administrative complaints as to whether or not you can choose that. So it's a different restraint. It's not something you're legally required to do, but your third-party administrator may force you down that road.
Well, and that's probably true for a lot of these optional requirements. I mean, some of these, as Tony and I both pointed out, are optional, not required. But you're going to have to talk with your administrator or your TPA and so forth to decide just how optional it is. And you may find that you're not given that choice, that they've made that choice for you. So that's just a good example of one. Hey, Dale, one more point I'm just going to add before our time runs out is they did give us one additional little thing, and it doesn't affect employee plans, but it's for IRAs, and so I figure you guys might want to know that. The rule used to be that you could no longer make contributions to an IRA once you hit that 70 and a half year-old requirement. So now they've changed it that if you have compensation after that, you can continue to make the contributions. You'll still have to start taking it out now when you're 72, under the rules that Tony described, but you have to do that. They also added a few layers of compensation that will be included as compensation even though they're technically not earnings. Things like if you get payment for foster care, I think was one of them. The other one I had to think about, but they've added a few other little obscure types of compensation that would be qualified for a contribution to your IRA. So
we still have to worry about being an active participant, whether it's a deductible contribution. That hasn't changed.
Yeah, that hasn't changed.
We did get a question, which is actually a Mike Riley question. Can you still make a charitable contribution from an inherited IRA and get the tax benefit of the charitable distribution? Since that's an IRA question, I'm looking at Mike.
Yeah.
They haven't changed the rule for a qualified charitable distribution, and that can still be done at 70 and a half. That rule did not roll up to 72.
Mm-hmm.
Well, for the sake of our audience.
I'll repeat that. But so Mike is telling us that they haven't changed the rules on charitable distributions from IRAs, and that includes inherited IRAs? rule applies to that?
No.
Oh, you cannot make a charitable distribution from an inherited IRA, or can you?
Oh, now you put me on the spot.
Uh-oh, well then I apologize. I apologize.
We're having-
Stay tuned for
he's
our
breaking up
estate
right now. I'm
planning
sorry. I
session,
can't hear
and
you.
Mike will answer that question
But
there.
as far as individuals, regular IRAs, charitable distributions, those rules have not changed, and that did not change to 72.
Correct, it's still 70 and a half.
It's still 70 and a half, all right.
We have one more quick question before we wrap up from the audience. Do you think not-for-profit employers will be able to terminate their old 403B plans and immediately start up a brand-new single-provider group annuity 403B plan to clean things up and start over? I suspect so.
That's the goal. That is the goal. I mean, it might not be so easy, but that's the
I would
goal.
think so.
Yeah, it's kind of counter to what they allow you to do with the 401k plan, which may be why the question has come up, because with the 401k plan, you can't just terminate, distribute, and start a new one up again. Do have some limitations, but hopefully that will be something they will tell us when they give us a little more guidance on how we can terminate the 403B plan.
Well, I think we've reached the end of our time, and we promised to conclude at 1 p.m. Eastern Time. If you have additional questions here in Cleveland, we're happy to talk to you after the program. For those of you viewing our webcast, you can still submit your questions. We will continue to follow these latest developments dealing with the Secure Act and the retirement plans, and I think there's going to be some more programs on the stretch IRAs that are coming out in additional guidance. You can visit our website, mcdonaldhopkins.com, for a replay of today's events, in case you can't sleep some night. We will email you a survey requesting feedback, and we encourage you to respond. We appreciate and we do take those things seriously and do use them in planning additional events. And thank you all for joining us.
Thank you.
Thank you.